I want you to picture a scenario. It feels like it was ripped straight out of a political thriller.
Right.
You have a sitting president, you have a leaked tape recording, a conversation supposedly about massive election rigging, and you've got generals, spies, a government that is, well, teetering on the brink of collapse.
It does sound like fiction, but, for those of us watching the Philippines in the mid-2000s, this was just the daily news cycle.
It was so intense. But here's the twist, and it's a huge one. Today's deep dive is not really about the scandal itself. We aren't here to debate who said what on those tapes or, if the election was actually stolen. We're here to talk about the moment the investigation just stopped. And it didn't stop because of a cover-up or a bribe or anything like that. It stopped because of a newspaper advertisement.
Or, to be more precise, the lack of one.
Which just sounds completely wild to me. The fate of a presidency is hanging in the balance, and the whole thing comes to a halt because someone forgot to run a classified ad.
It sounds absurd on the surface, I grant you that. But we're looking at a consolidated Supreme Court decision here. And our mission today is to unpack how the highest court in the land had to balance the public's screaming demand for the truth against the boring, rigid requirements of due process.
So on one side, you have the truth with a capital T.
Exactly.
And on the other, you just have the rule book.
And the court had to decide.
Yep.
Is this so-called technicality just a nuisance, or is it actually one of the most important safeguards for your liberty?
I love it. High stakes, petty details.
Okay.
Let's unpack this. Set the stage for us. What was happening before all the lawyers got involved?
We have to go back to the Hello Garcia scandal. This was about 3 years before the Supreme Court decision we're analyzing. The source material describes a really volatile atmosphere. Tapes surfaced.
Wiretapped conversation.
Ostensibly, yes.
Yeah.
Purportedly between the president and a high-ranking Cumalic official, Commissioner Virgilio Garcillano.
Hence the name. Hello, Garcia.
Precisely. The allegation was that the president was instructing Garcillano to manipulate the 2004 election results. The decision itself actually notes this controversy caused the near collapse of the Arroyo government.
So of course Congress wants to investigate. I mean, if that's not a reason for a hearing, I don't know what is.
Correct. And both chambers jumped in. First, the House of Representatives. It all started with a speech by Representative Francis Escudero called Tale of Two Tapes.
They really go for the dramatic titles, don't they?
They certainly do. And it was dramatic. There were these intense debates. The NBI submitted what they called original tapes.
Yeah.
There was a huge fight about whether they were authentic. But eventually the House actually played the tapes. They listened to them right there in the chambers.
So the cat was out of the bag in the House. They heard them.
Yes. They eventually suspended the hearings but decided to write a committee report based on what they'd heard. But then things went quiet for a couple years. Until the Senate decided to revive it. In a way, Senator Panfilo Lacson gave a speech called The Lighthouse That Brought Darkness.
The Lighthouse That Brought Darkness? That sounds like a horror movie.
It definitely sparked a horror show for the administration. And this speech started a whole new inquiry in the Senate. This is where the legal trouble really begins. 2 investigations, 2 separate legal challenges.
So who's trying to stop these investigations? Because usually when someone tries to stop an investigation, it looks like they have something to hide.
We have 2 different sets of petitioners. In the first case, against the House, the petitioner is Virgilio Garcillano himself.
The man on the other end of the phone line.
Allegedly. He filed a petition to stop the House from using the tapes. He argued they're illegally obtained wiretaps. He wanted them, stricken from the record.
Okay, that's case 1, Garcillano versus the House. Pretty straightforward self-preservation. What about the Senate?
Case 2 is different. The investigation hadn't really gotten started yet. And the petitioners here, they weren't the targets. They were 2 men named Santiago Renata and Oswaldo Cawili.
And who are they?
They're actually retired justices. And later, a major from the Intelligence Service of the Armed Forces, a Major Sag, he intervened as well.
Wait, hold on. Why do 2 retired judges care if the Senate investigates a political scandal? What's their skin in the game?
That is the million-dollar question. They argued the Senate inquiry violated the anti-wiretapping law, basically saying you can't hold a hearing where your main piece of evidence is a crime to possess. They were arguing on principle.
But wait, if they aren't the ones being investigated, how are they even allowed to sue? This brings us to that legal term I see in the notes. Locus standi.
Right, legal standing. Usually to sue the government, you have to prove that you personally have been hurt or will be hurt by what they're doing. You need a direct injury.
Which Garcillano obviously had. He's the guy on the tape.
Exactly. The court said Garcillano clearly had standing. He was publicly identified. He was the subject of the investigation. But the retired justices, they were just citizens.
So did the Supreme Court just kick their case out, say, mind your own business?
No. And this is where it gets really interesting. The court, it relaxed that direct injury test. They cited the principle of transcendental importance.
Transcendental importance. That sounds heavy.
It means the issue is so big, so critical to the public and the Constitution, that the court will allow a regular citizen to sue. They also noted that, these hearings cost taxpayer money. So as taxpayers, they have a right to question if that money is being spent on something illegal.
So the court basically said, this is too big for us to ignore just because the wrong person filed the paperwork.
Precisely. And they also allowed Major Sag to intervene because he was being summoned to testify. He argued his right to due process was at risk because he might be detained. So the court says, okay, everyone's allowed at the table. Let's decide these cases.
All right, so we have two battles, the House investigation and the Senate investigation.
Yeah.
Let's look at the scoreboard. Who won?
It was a split decision. And the reasons are fascinatingly different. Let's start with the House. Remember, Garcillano wanted to stop them from using the tapes and writing their report.
Right. Scrub the record.
The Supreme Court dismissed his petition. They said it was moot and academic.
Which is legalese for it doesn't matter anymore.
Pretty much.
Right.
The court pointed out that the tapes had already been played. The members of the House had heard them. The reports were already submitted.
You can't unring a bell.
That's it, exactly. The court said prohibition is a prevented remedy. You use it to stop something that's about to happen. You can't use it to stop something that's already done. So Garcillano lost that round just because he was too late.
Okay, so the House got away with it because they were fast. Now, what about the Senate? This is the one that really surprised me.
The Senate verdict,
Yeah.
yes. The court granted the petition. They ordered the Senate to stop the investigation. Dead in its tracks.
Now, I assumed this was because of the wiretapping thing. The retired justices argued that playing the tapes was illegal. Is that why the court stopped them?
You would think so, right? But the court, it didn't even touch the wiretapping issue. They didn't need to. They stopped the whole thing on a completely different ground.
And what was that?
Article 6, Section 21 of the Constitution.
Okay, lay it on me. What does it say?
It says, inquiries in aid of legislation must be conducted in accordance with its duly published rules of procedure.
Duly published rules of procedure. That sounds incredibly bureaucratic. The Senate has rules, right? They've been around forever.
They do. And that was the Senate's whole defense. They said, look, we published our rules in 1995, and again in 2006. We have rules.
So what was the problem? If the rules exist, why can't they use them?
Yeah. The problem is a concept called the continuing body fallacy.
Okay, let's break that down.
We tend to think of the Senate as this, permanent thing. It's always there. But the Supreme Court clarified that while the Senate as an institution is continuous, the Senate of each Congress is not.
Because of the elections.
Right. Every 3 years, half the body finishes their terms. The composition changes. So when a new Congress starts, like the 14th Congress in this case, it's technically a new body.
So just because the last Senate agreed on how to run an investigation, that doesn't mean the Senate has agreed to it.
Exactly. The rules on unfinished business in the Senate even state that all pending matters terminate at the end of a Congress.
In the slate.
And if the legislative slate is wiped clean, then the procedural slate has to be too. The court said the Senate of the 14th Congress hadn't published their rules for that Congress.
So they were basically operating without a license.
In a manner of speaking, they were trying to detain people, remember Major Sag, and compel testimony using rules that legally didn't exist for them yet.
But wait a minute, we're in the modern world here. Well, the late 2000s. The Senate argued the rules were on their website. They were in booklets. I mean, if I want to know the Senate rules today, I just Google them.
And that is exactly what the Senate argued. They cited the Electronic Commerce Act, saying, hey, the internet counts. A PDF is as good as paper.
And the Supreme Court said?
They said, absolutely not.
Really? That feels, well, it feels incredibly old-fashioned. Why doesn't a website count as publication?
It feels that way, but let's look at the reasoning, because it's actually very protective of the citizen. The court cited a landmark case, Tañada v. Tavera. It says laws must be published in the official gazette or a newspaper of general circulation.
But again, why? Why is a newspaper better than a website?
The court made a distinction between evidence and notice. The Electronic Commerce Act makes digital documents valid for evidence in court, but it does not replace the requirement for publishing laws to give notice to the public.
So evidence is about proving something. Notice is about telling people what the rules are.
Correct. And think about the burden. If you publish in a newspaper, it's an active declaration. It's out there. If you just put it on a website, you're shifting the burden to the citizen to go find it, to have internet, to know the URL. And more importantly, the court emphasized that this is about liberty.
Right.
In these hearings, the Senate can have you arrested and detained.
That's serious power.
So if the government is going to have the power to take away your freedom, the rules of the game must be crystal clear and publicly notified in the strict way the Constitution demands. A PDF on a website just isn't enough when your liberty is on the line.
That is a powerful point. It's easy to roll your eyes at newspaper publication until you're the one being dragged in front of a committee.
Exactly. And Justice Carpio pointed out that the Senate's own rules, the ones they were trying to use, actually said that they take effect 7 days after publication in newspapers.
Wait, really? Their own rules said that?
Yes. So the Senate was arguing that they didn't need to follow their own rules about how to make the rules effective.
Talk about being hoisted by your own petard.
Indeed. So the court ruled, until you publish those rules in a newspaper, you cannot conduct this investigation. No subpoenas, no contempt citations, nothing.
So let's just recap this. The House investigation died because it was already over. It was moot. But the Senate investigation was blocked, not because of wiretapping, not because of immunity, but because the Senate used their website instead of running a newspaper ad.
Essentially, yes. They failed to satisfy that constitutional requirement of duly published rules of procedure.
And the court didn't even bother ruling on the wiretapping issue at all.
Nope. They basically said, we don't need to answer the hard question about wiretapping because you failed the easy question about publication.
That is wild. It feels like getting off on a technicality, doesn't it? The public wanted to know if the election was rigged, and the court is talking about which newspaper the rules were in.
It does feel that way, and I'm sure for people at the time it was incredibly frustrating. But if we step back, it's actually a powerful defense of the rule of law.
How so? Walk me through that.
Imagine if any government body could just make up the rules as they go along, or change them without telling anyone, or just say, oh, the rules are in a drawer somewhere, just trust us.
That sounds like a kangaroo court.
Exactly. The Supreme Court was saying that the process of finding the truth is just as important as the truth itself. You cannot break the law to enforce the law.
So even if those tapes contain the smoking gun of the century, the Senate couldn't investigate until they followed the basic housekeeping rule of telling everyone how it would work.
That's the core of it. That rule isn't just a suggestion. It's a shield. It protects the witness. It protects the accused. It ensures that when government flexes its muscles, it does so within the boundaries of fair play.
This really changes how I look at technicalities. We use that word to mean a loophole for criminals. But here, the technicality is the Constitution itself.
The Constitution is a document made entirely of technicalities, if you look at it that way. But those technicalities are the difference between a democracy and a dictatorship. They're the brakes on the car.
That's a great way to put it.
It's true. The court had to choose. Do we let the Senate proceed because the issue is explosive? Or do we stop them because they missed a procedural step? They chose procedure.
So what does this mean for us today? We see legislative inquiries all the time.
It means when we watch those hearings, we should look beyond the headlines. We should ask, are they following the rules? Are the rights of the people they're questioning being respected? Because if the government cuts corners on the small stuff, it's a slippery slope.
And it's a reminder that in the eyes of the law, a website is still not a newspaper.
Not yet, at least. The principle of notice, that you have a right to know the laws that govern you, that's timeless. The government has to tell you the rules before they play the game.
It's a fascinating case, a political storm quieted by the finest of fine print.
Which is why we read the decisions, not just the news reports.
Absolutely. Well, that brings us to the end of this deep dive. A story about tapes, presidents, and ultimately the power of procedure.
And here's a thought to leave you with. We often get angry when we feel like justice is delayed by bureaucracy. We want the bad guys caught now. But consider this. If the Supreme Court had allowed the Senate to proceed without published rules just because this issue was so important, what precedent would that set for an investigation into you?
That's a chilling thought.
It is. If the importance of a topic lets the government ignore the Constitution, then the Constitution isn't really the supreme law anymore, is it? It's just a suggestion. And a suggestion won't protect you when you're the one in the witness chair.
Something to chew on. Sometimes the red tape is the only thing holding the whole structure together.
Thanks for listening, and we'll catch you on the next Deep Dive.